ठीक से दोबारा निकाला। हाँ, एक बार फाइनल हो तो
Can we start the program, your lordships and all our distinguished invitees?
Yes, please. Yes, please. Go ahead.
Yes. Good evening. My name is Amrit Bhargav, a lawyer based out of Chennai, and it is my pleasure to take you through the virtual release of this 26th edition of Ratanlal and Dhirajlal on the law of evidence, edited and commented by Mr. N. Vijayaraghavan and Mr. Sharat Chandran, published by LexisNexis Butterworths, with today's virtual event being hosted by the current Tamil Nadu cases, Tamil Nadu's prestigious legal reporter. By way of beginning, let me request Ms. Bhargavi Vijayaraghavan and Ms. Ranganayaki Vijayaraghavan to render an invocation.
Vandeham Sharadam Visharadam Jnanam Varadam Vande Sharadam Visharadam Jnanam Varadam Vandeham Sharadam Visharadam Jnanam Vandeham Sharadam Visharadam Jnanam Varadam Vandeham Sharadam Sarva Swarupinim Hridaya Nivasinim Shodha Sarva Swarupinim Hridaya Nivasinim Swaprakash Rupinim Swaprakash Rupinim Swaprakash Rupinim Vandeham Sharadam Visharadam Jnanam Varadam Vandeham Sharadam Paravidya Bhushita Paravidya Surava Sujana Sevita Sulabham Subhadam Susvanavadam Niratam Vandeham Sharadam Visharadam Jnanatam Varadam Vandeham Sharadam
Thank you. It is my pleasure to request Mr. R. Shankar Narayanan, Senior Advocate, Additional Solicitor General of the Madras High Court and Editor of the current Tamil Nadu cases, to welcome their lordships today's galaxy of guests and invitees.
Good evening to all. I can rightfully say that N. Vijayaraghavan is a good friend of mine. But little did I know that I would be asked to welcome this gathering, but of course I deem it a great honor. I am elated to welcome everyone to the book launch of Ratanlal Dhirajlal on Law of Evidence, LexisNexis, Butterworth's 26th edition 2022, edited by N. Vijayaraghavan and my young friend Sharat Chandra. This is probably Vijayaraghavan's 5th book release in the last 6 months. And truthfully, I have lost count. I do not know what he's doing. So this is subject to correction. But he has already, as I think, as I am talking, he would be typing a book right now or an article for some journal. I only hope that the publishing house will be able to keep up with this pace, but I know for sure his readers have to dedicate the bookshelf for his books alone. This event is organized by a library of CTC, which is under the umbrella of current Tamil Nadu Cases Group. This group is publishing about 4 journals. It is a matter of pride to mention that CTC group of journals was started in 1995 by Mr. S. Ramachandran, who came to Chennai from Mayavaram to set up his shop as a bookseller. The CTC group has grown leaps and bounds ever since by sheer hard work of Mr. Ramachandran, alongside the unqualified support of few lawyers. CTC has spread far more to have 5 journals under its wing and various sub-projects such as CTC Library. We also have a blog where people do contribute articles not only related to law, but other subjects also. It is my pleasure to invite the presiding guest of this evening, Hon'ble Mr. Justice U.U. Lalit, Judge of the Supreme Court, whose proficiency and mastery of criminal law is boundless. The presence of His Lordship for this book release assumes great importance to every participant in this meeting. My Lord Justice Lalit, we welcome you on behalf of the CTC Library and all those who are present here.
Thank you.
It is a pleasure to welcome back Honorable Mr. Justice V. Ramasubramanian and Honorable Justice M.M. Sundresh to the CTC event and among the bar of their parent High Court. My Lords, I welcome both of you, and your Lordships have participated in all our functions, have patronized our journal, and CTC was always for its growth to both the Lords. It is a privilege to invite Justice P.N. Prakash of the Madras High Court, whose contribution to the law of evidence is substantial. Lord, I welcome Justice Seshasai, Justice Vaidyanathan, Justice Abdul Kudos, and Justice Seshadri Naidu. I am unable to see it from the participant. If I have missed something, I may not be mistaken. I welcome all other judges who have logged in this meeting and my colleagues in the bar and everyone else. Thank you so much.
Thank you, sir, for those gracious words of welcome. For the prime moment of today's evening, we now have the book launch. May I request His Lordship Justice U.U. Lalit, Judge, Supreme Court of India, to kindly unwrap the book and symbolically hand over the first copy to the Honorable Mr. Justice V. Ramasubramanian, Judge, Supreme Court of India.
Here's the book for Justice V. Ramasubramanian. I am just passing it on through virtual platform. Accept it, sir.
Thank you.
Thank you, Your Lordships.
Yes.
I have the privilege now of requesting His Lordship Justice M.M. Sundresh, Judge, Supreme Court of India, to kindly unwrap the second copy of the book and symbolically hand it over virtually to the Honorable Mr. Justice P.N. Prakash, Judge, High Court of Madras.
With immense pleasure.
Thank you.
Same copy to my brother, Mrs. P. N. Prakash.
Thank you. Thanks a lot.
Thank you, Your Lordships. May I request all of you to kindly lift up and show copies of the book for our own photo moment now.
Justice Ramasubramanian's copy is with me.
Thank you, Your Lordships. Thank you. This evening is special for a variety of reasons. The most important being the presence of His Lordship Justice U.U. Lalit, Judge, the Supreme Court of India. May I now humbly invite His Lordship to deliver the presidential address.
Justice Ramasubramanian, Justice Sundresh, all the honorable judges who are present here. I need not name every one of you, the authors of this excellent work, and all those who are associated with the publication of this book. Ratanlal Dhirajlal is a name which is, every law student hears that name from first year of his law course and goes on till he continues to be in practice. Law of evidence itself is 150 years old now. The commentary itself is more than 100 years old. It started. Law of evidence has always been something like that, whether if you appreciate it well, if you understand it well, it comes to your rescue like anything. But if you don't know the nuances of that, then it can always remain as a stumbling block. But it's a brilliant piece of work. Every time, whenever, right from now almost 35 years that since I entered law college, more than that, 40 years now, every time whenever there is a problem, you always go to the basics, and that is Ratanlal Dhirajlal. You don't go to anything else. I still recollect those small copies, Law of Evidence, CRPC, then torts and everything. So I still retain those small copies with me, though the editions have now actually been multiplied. Law of evidence has stood the test of time. Barring 3 sets of amendments, we still have the original text. The first set of amendments came when dowry related sort of offenses were to be taken care of, and the ideas and rules of presumption had to be tweaked and changed a bit. So we had those sections which are 113A, 113B, which were introduced. Then the next set of amendments came when we had to deal with the passage of time, with the advancement of technology. Virtual platforms became the rule of the game, became the order of the day. So therefore, electronic evidence, how does it actually be taken into account? How should it be taken into account? So we have those host of amendments which came. Then the third part is whenever sexual offenses are concerned, and if a lady says that she was actually taken advantage of, then what kind of presumption should be drawn? So 114A. These are 3 major shifts which have occurred. Barring that, the law of evidence has remained same. We are all aware that rules of evidence in certain special enactments have taken a different rule. Say, for instance, Section 20 in Prevention of Corruption Act, it draws a statutory presumption, or presumptions under NDPS Act. These are individual acts where certain rules of presumption have been changed to suit the convenience, to suit the requirements of the day. But barring that, barring everything, the law of evidence has stood the test of time. And hats off to the author who drafted this original Evidence Act. And what is of greater significance is that a book like this, which is so well edited, it will always be a helping hand to all the young lawyers, budding lawyers, while young budding lawyers, even to judges as well, correct? So therefore, all students of law will always find this book to be can be relied upon, which can be consulted at anything wrong.
वॉल्यूम मैं बढ़ा दूं.
Oh, there are so many noises coming. Just 1 or 2 things before I hand over the mic to other speakers. See the changes in times. Expert evidence, Section 45. We always say that the classical test is that the expert is only a assisting evidence. Ultimately, everything has to be taken note of and relied upon, and the assessment has to be made by the principal judge himself. It's only an opinion evidence. But with the passage of time, certain areas like fingerprint expert have now taken the level of a science which is dependable science and is not just an opinion evidence alone. The courts rely heavily on fingerprint experts' opinion if that opinion otherwise is supposed to be without any blemish. Now, these are some of the areas, but the Evidence Act primarily is just what it has actually. We have received it 150 years ago. And it's a brilliant piece of work. The brilliant piece of work is it's an icing on cake that Ratanlal Dhirajlal has now been edited, and it's a new edition which has come out. I went through the foreword which has been given by my learned brother Ramasubramanian. It's equally fascinating. So I wish all good luck to everyone, the authors, the publishers, everybody who is associated with this. And I hope this edition of Ratanlal Dhirajlal will always be relied upon by law students, advocates, judges, and everybody connected with the field of law. Good luck. Thank you. Thank you.
Thank you, my lord, for those anecdotal vignettes, illustrative examples, and for tracing the jurisprudential journey of evidence, the art and science of that law. This 26th edition of the book contains an edifying foreword by His Lordship Justice V. Ramasubramanian, bristling with instances of a law of evidence drawn from cultural references. And may I now humbly invite His Lordship, Justice Ramasubramanian, to deliver a special address to us this evening.
Honorable Justice Uday Umesh Lalit, my brother Honorable Justice M. Sundresh, my good friend Justice P.N. Prakash, my former colleagues at the Madras High Court, Justice Yashadri Naidu, all other judges who are invisible, whose voices cannot also be heard like Ashariri. They are actually Ashariri. The authors of the book, Mr. Vijay Raghavan and Sharat Chandran, the learned Additional Solicitor General Sri Shankar Narayanan, Sri Amrit Bhargav, all of the distinguished invitees. What makes law very interesting is that sometimes it is perceived by common man to be crazy. Many times common man thinks that law is crazy. Fortunately or unfortunately, common man's perception to a great extent is influenced by the law of evidence. You don't have to look anywhere else to appreciate this phenomenon. Take, for instance, what happened today. Today, Honorable Mr. Justice U.U. Lalit virtually released and handed over a copy of the book to me. There is electronic evidence to show that I was handed over a hard copy. But as a matter of fact, I don't have the same. Therefore, there is a fact which is established by evidence, but I know that that fact is not true as a matter of fact. This is what makes the law of evidence very interesting for the lawyers and judges, though not necessarily for the common man. An interesting case came up before the succession court in Hancock of the state of Ohio in the United States in the year 2014. A person by name Donald Eugene Miller went missing from August 1986, leaving his wife and 2 children in the lurch. His wife, Robin Miller, filed a petition in the succession court in 1994 after a period of 8 years, since he went missing, for a declaration that her husband should be presumed to be dead. After ordering the publication of notices in the local newspapers for 4 consecutive weeks, the court passed a decree on 31/5/1994 declaring that Donald Eugene Miller should be presumed to be dead and that his minor children should be granted benefits under the Social Security scheme of the government. After 19 years of such a declaration, Donald Eugene Miller surfaced and he applied for a driving license. But the transport department rejected the application on the ground that no driving license could be issued to a person who is dead as per law. Therefore, he filed a petition in the year 2013 in the very same succession court seeking to set aside the decree of declaration of presumed death. But his wife opposed the petition on the ground that the petition was barred by limitation, as it was not filed within 3 years from the date of the decree. The court accepted the objection, sustained the objection taken by the wife, and rejected the petition filed by Miller. The result was that Miller was dead in law, though in fact he was alive. We all know the presumptions under section 107 and 108 of the Evidence Act. While section 107 presumes life, section 108 raises a presumption of death. But the difficulty with these two provisions is that though a presumption arises that a person is dead after a lapse of 7 years, the date of death is not fixed. There is almost uniformity of law throughout the world about the presumption of death, but there is no uniformity in fixing the date of death. This section 108 normally poses problems when it comes to government servants. Whenever a government servant goes missing and is not traceable for a period of 7 years, his spouse approaches the court and gets a declaration of deemed death. But the moment she applies for terminal benefits and also for compassionate appointment, invariably the governments come up with a stand that during the period when he was absent, disciplinary proceedings were initiated for unauthorized absence, notices were attempted to be served, they could not be served, therefore inquiries proceeded ex parte and orders of dismissal passed within a period of 2 to 3 years. These cases come up at the instance of the spouses. Many of the high courts have taken a view in this country that it is not the date on which the presumption arises, but even the date on which the man went missing could be taken to be the date of death. Therefore, some of the courts have taken the view that the disciplinary proceedings were initiated by the government against a dead person and they were not valid in the eye of law. Therefore, courts have granted relief in favor of such persons. This conundrum in law, if we really have a look at the origin of this law, you will find that in the Western world, this law can be traced to the year 1603. In Britain, when sailors who went on long voyages on the seas returned home after several years, they found their wives remarried to other men, presuming that this man is dead. Complaints of bigamy used to get filed by the husbands, sailors who returned home to find their wives already happily married. Therefore, a rule was introduced in statutory form in section 1 of the English Bigamy Act of 1603, which provided a defense to a charge of bigamy if either of those who were charged marry a second time when the first spouse had been beyond the seas for 7 years, or those whose spouse had been absent for 7 years, although not beyond 7 years. This 1603 Act was incorporated later in a 1666 Act, and later adopted in the Life Estates Act 1695. Subsequently, the law has now an act called the Presumption of Death Act has actually been passed in the year 2013. When we come to India, come to the Indian context, some of these Smritis appear to have recognized this rule thousands of years ago. At least 4 Smritis, namely Manusmriti, Narada Smriti, Gautama Smriti, and Vasishta Smriti, have recognized this. For instance, Narada Smriti contains a verse in chapter 12 under the heading Relations between Men and Women, verses 98 to 102. It says a particular category of women should wait for 8 years for the husband who has gone away to return. If she has no children, it is enough if she waited only for 4 years. Another category of women need to wait only for 6 years if she had children. It is enough if she waits for 3 years if she had children. Similar rules can be found in certain other smritis also. But these smritis also did not throw light upon the actual date of death. So this is one of the areas for which I think the Evidence Act has got no answer. But the 2013 Act in England has attempted to fix a date of death also. I think these are areas in which the authors could also focus so that they can come up with certain original thoughts as to how the existing act could be improved, or what the connection that the existing act has to whatever our forefathers have laid down. As Honorable Justice Lalit pointed out, it is a good attempt. 150 years have passed from the date on which the act came. 100 years have passed from the date on which the commentary was first made. And this is the 26th edition. There is some connection between all this, 150, 100, and the 26th edition. I congratulate the authors and the publishers for this wonderful work. Thank you for this opportunity.
Thank you, my lord. That law is crazy is now an adage that we will remember. That, along with the old saying that both fact and law are stranger than fiction. Deep, absorbing, and riveting, your lordship has set the tone this evening. It is my privilege to invite His Lordship Justice M.M. Sundresh, Judge, Supreme Court of India, to deliver a special address to all of us.
Honorable Justice U. Lalit, Honorable Justice V. Ramasubramanian, my dear brother P.N. Prakash, Learned Additional Solicitor General, Mr. Vijay Raghavan and Sharath, my distinguished colleagues from the Madras High Court, Mr. Sheshadri Naidu, whom I don't call him as a former judge, but only a senior advocate, and other distinguished invitees. I have an enormous task. 2 distinguished speakers of immense knowledge have spoken before me, followed by my brother P.M. Prakash, whose knowledge in the field of Evidence Act is well known, at least for those who are well acquainted with him. At the outset, I would like to congratulate the publishers and the 2 editors. I will say that a remarkable work has been undertaken and performed with sublime clarity by both Mr. Veerayaman and Sharath. Evidence law, in my view, is a substantive law, is an adjective law. Now, what do we mean by adjective law? It may have the trappings of a procedural law or a substantive law, but it stands on its own. It clears a path for a substantive law. There is an interesting saying comparing people with books. It is said that few of them can deceive one by their cover and the others by their content. This book doesn't deceive us, nor it throws out any surprise. An excellent edition has been brought out by the hard work of both these editors. Evidence as we could understand from the ancient time, based upon the very same foundational principles of justice, equity, and good conscience. As Justice Ramasubramanian has spoken, in the ancient times, the certain principles remain to be the same. A party has to prove his own case, admission as a relevant fact, rule of estoppel, rule of res judicata, and the party who alleges a fact has to prove. All these principles were very much there. During the medieval period, when the Sultanate came, with the onset of the Muslim rule, and with the strengthening of the slave dynasty onwards, ending with the Mughal rule, the Islamic law came into being. But the notable factor to be kept in mind is that they did not enforce it on the native Indians. When the East India Company entered the shores of this country and established 3 presidencies, Bombay, Madras, and Calcutta, they brought forth certain principles of evidence. However, even there, when it comes to the native Indians, they made consultation with Maulis and Pandits. Options were once again given to the parties. Now, but it created some problem with the expansion of the territories by the company. How do you apply to the Mufasal area? And is there any uniform rule of evidence to be applied between the Mufasal areas on the one hand and the presidencies, and secondly among the presidencies? Now, Lord Macaulay, being the head of the first law commission, in the year 1833, introduced the first enactment, which came into the year 1935 through Act 10 of 35. From then onwards, amendments started coming in. When the Great Mutiny happened in 1857, leading to the British government taking over the entire territories from the company, the need for strengthening was felt. There is a notable judgment of the Privy Council which said that you can't ignore and avoid the native rules of evidence. In Venkatadri's case, the Privy Council said the issue was on the admissibility of a copy of a document which itself was a copy. The Privy Council held what has been pursued over the years cannot be replaced by understanding of the rule of evidence. Then Lord Maine, placing reliance upon 2 of the Law Commission reports, placed a draftful before the Legislative Council. It was referred to the Select Committee, and surprisingly, the Select Committee rejected it. Inter alia, holding the officers are not expected to know the law of evidence. Then James Stephen took over and he created the present law of evidence. In his speech, he has said, I made a genuine attempt to reconcile the law of evidence as we have with the unique characteristics of the law of practice in vogue in this land. Now, with this background, if you see the enactment, as Justice you Lalit has said, almost all aspects have been considered at length. Now, I asked Sharad and Vijay, I want to furnish a copy of this book just to know how much of improvement they have made. Honestly speaking, I could not go beyond section 3 and 4. On a reading of this provision over and over and again, though these provisions define the words mentioned thereunder, they are the core of the Evidence Act. Be that maybe the definition of fact, fact in issue, relevant fact, or evidence as defined, followed by what is proved, not proved, and disproved. Now, one has to understand the true meaning of these definition clauses. Read with section 4, as Lalit has rightly touched upon, what shall be presumed, may presume, shall presume, and conclusive proof. Lot of thought process has gone into it. And then how an understanding has been created by the authors, giving an extreme amount of extent of flexibility to the court in consciously avoiding the word evidence when it comes to fact proved by replacing it with matter. I believe more we read, richer we become. Even on this aspect, I found substantial research has been done by both editors in defining and improving the interpretation of these clauses. Not only the judgments of the Supreme Courts, but the judgment of the High Courts were also taken into consideration. My congratulations once again to both the editors and publishers. I hope and wish that you will have more such edition in future. Thank you very much for giving this opportunity.
Thank you, Your Lordship, for that primer on legal history. Your Lordship's emphasis of the timeless principles of justice, equity, and good conscience, along with conceptual explication, commands our gratitude. In a scholarly introduction that promises an exhorting reading, His Lordship Justice P.N. Prakash lays bare the intersection between law, culture, and the ethos of a civilization, underscoring the felt needs of a judicial system. It is my pleasure to invite His Lordship Justice P.N. Prakash, Judge, High Court of Madras, to say a few words on this occasion.
Thank you. Honorable Mr. Justice Lalit, Honorable Mr. Justice Ramasubramanian, Honorable Mr. Justice Sundresh, my brother judges, Justice Seshadri Naidu, the Additional Solicitor General, the erudite authors, and my friends who are there. A fine good evening to you all. I will just state the circumstances under which I wrote this introduction for them. See, in the temple town of Kumbakonam, from where Justice Ramasubramanian also hails, there is an advocate whose passion is to teach rural lawyers from the rural area and make them to crack this judicial service examination. He is very strong in the Evidence Act, and for the rural students, he translated the Evidence Act into Tamil and requested me to write an article for his book. Now, I wrote an article for his book, and this article came to the author's knowledge, and they requested me to write something similar for them. So I took the cue from what I had written for Mr. Sukumaran. The lawyer whom I'm mentioning is Mr. Sukumaran. Is from the Mofsal Bar, very, very strong in the Evidence Act, and as well in the Indian Penal Code and Contract Act. he has written a book in Tamil. And a very, I mean, it's so simple for the students as well for the lawyers with illustrations. So what I wrote for him, I took the cue from there and I just wrote for these people too. Well, I would just like to share. I would like to share my experience on this. I mean, my career had been I was a police court lawyer. I was a lawyer practicing in the trial side throughout my career, and examining witnesses, cross-examining. This is what my career was throughout. But one question used to nag me every time: why I am doing what I am doing? This question I used to ask, why should I put this question, if at all? How relevant it would be in a particular case? So this thought, why I am doing what I am doing, which always nags me even today, made me to study the Evidence Act and try to pigeonhole each question, each answer into one of the 5 to 55 sections of the Evidence Act. It was like working on a crossword puzzle. So interesting it will be that when you ask, supposing you ask a test identification parade, it is not relevant under section 9, but it is a corroborative piece of evidence under 157. So these are all the small things, you by sheer trial and error, you by practice in the trial courts, in the magistrate court and the sessions courts, I learned these nuances of this act. Otherwise, it's very difficult to understand this act in abstract. I can tell you with certainty, up till 1990, doing a criminal trial in a sessions court was always a challenging job, because we had on one side an array of public prosecutors like Rajamanikam, Dante, Daniel, Viluppuram Subramanian. These two people were so thorough in Evidence Act. Then you had on the defense people like this, Mr. N.T. Vanamalai, N. Natarajan, Velur Varadarajan, Selam Parsadi, Coimbatore Mailswamy. These were all, and of course, Tiruchi Reddyar. All of these people were also equally thorough. Then you had a class of judges. This is Kadar, this is Rangasamy, K.E. Vardhan, this is Siddiq. And before a trial, when you have to do a trial before these people, there cannot be possibly one-upmanship, because they all the three, the judge, the defense lawyer, and the prosecutor knew the law so well. And the defense used to take such defenses that they bear in mind 105, 106 of the Evidence Act, and accordingly they would adduce evidence. From the cross-examination suggestions up to 313, it used to be one beautiful line, and at the end of the 313, they will let in one DW1 or DW2 to finish the case. This is how it was. But post 1990, as the law education started declining, we really do not have good law teachers anywhere to teach the nuances of the Indian Evidence Act. This is what is my real concern. Today, I can tell you with certainty that a talented criminal lawyer is one who is able to protract the trial as long as possible, see that the evidence gets disappeared, or suborn the witnesses. This happens because the law of evidence is almost become obsolete in our courts these days. Maybe it is one reason could be that the individual accused, because most of them are big time people, be it politicians or business people, they are becoming more and more stronger than the system, and the system seems to be creeping before them. That is perhaps is making these laws totally thing, and they are practically adopting the system of suborning witnesses and getting an acquittal and going. So there is no great one-upmanship today in trials. And when you and the trial court judgments are also convicting the judges, convicting the accused with convoluted thing. The reasons given by the trial court judgments, when it comes to the High Court as well as Supreme Court, they'll be really surprised. Some of them rely on 161 statements and give conviction. Some such things do happen throughout because there is lack of erudition. There are no good teachers of Indian Evidence Act to pigeonhole each concept between 5 to 55 and do the case. So these are all the things. In this dark thing, you see, we have this book which is come by Vijay Raghavan and Sharath, about whom everyone knows. As Vijay Raghavan, this is the fifth book for Vijay Raghavan. As far as Sharath is concerned, at the age of 35, he has brought the second book, the first book being Commercial Courts Act, for his no less than Justice Nariman had written the foreword while he was a Supreme Court judge, and this second edition has come. And in this edition, what is the difference in this edition is you can find critical comments of the authors at various places. Very critical comments. For example, they would have discussed about Tufan Singh's case. What is the scope of a statement given by an accused under Section 67 of the NDPS Act, whether it could be hit by Section 25 or not? A very good discussion is there. And under Section 10 of the Evidence Act, then again, contradiction and corroboration, 157, 145, 157. These are all the areas where quite a lot of materials I find in this book, and it's really a very good endeavor. I feel that nothing is still lost because there are bright young students like Amrit Bhargav and all this group of students who are coming up now from the law colleges who have a passion for law. And I'm sure this magnum opus, this textbook would be of great use to those who want to really understand the Indian Evidence Act and implement it in the system. But if Justice Midha, while retiring in Delhi High Court, he said a profound word. He said, it is the parties who know the truth in all trials, and it is we judges who are put on trial, because there is so much of perjury in the system that it makes the judges to render justice in such a climate very difficult. I read Justice Midda's words somewhere in the paper, and I felt it is very appropriate. But let us really hope that in days to come, the system rises up and becomes stronger to deal with people who are trying to grow beyond the system. So with this, I really thank the authors for giving me an opportunity to write an introduction for this book. I also congratulate the authors, and I'm very confident that this book will adorn all the libraries and people will get enriched by it. Thank you. Jai Hind.
Thank you, my lord, for that trip down the memory lane. Your lordship's vivifying address was explorative and made us understand the importance of this seminal contribution to criminal jurisprudence. The book has now been released and is open for our intellectual flavors to relish. For the authors, it has been a labor of academic input and intense research. May I invite Mr. N. Vijayaraghavan to deliver an acceptance address.
Good evening, ladies and gentlemen. We are really grateful for all the learned judges for making time on a Friday evening when law is lost on the subject of any lawyer, to the best of my knowledge, for the past 30 years. We're extremely grateful for their grace to spare time and be here and release the book and give their words of wisdom. I'll make it very, very brief because it's been long enough and you may be tired. So let me say this. My interest or passion in evidence was triggered by the late lamented Justice M. Srinivasan. I was arguing a case before Justice M. Srinivasan and Justice S.S. Subramanian, Triple SJ we used to call him. When I was addressing, as is my habit, when I got involved and passionate, I raised my voice a little bit. Immediately, Justice Srinivasan said, by raising your voice, you cannot make out a case. Please, young man, once I was a young man, not so young now. He said, young man, please understand this proposition. There are two things which are absolutely true in the world. One is, this too shall pass. The second thing that a lawyer should learn is, law is in search of proof, not truth. He repeated it for me. Law is in search of proof, not truth. If you have the proof to back the truth that you are trying to pursue and prove in a court of law, then you triumph. If it fails, if there is no adequacy of proof as laid out by Stephen in his law of evidence of 1872 vintage, don't blame the judges for having upheld falsehood. Please don't do that. Thereafter, my interest was triggered in that I started reading very much on that, and Vepasarathi was my next stop. I read Ratanlal and Dhirajlal like a storybook, and then Vepasarathi, Ratanlal and these words of M. Srinivasan triggered me. And then I wrote my first book with Justice K. Kannan, as he does, was in the Punjab High Court. And then it went to Sharat Chandran, came on the scene, and therefore I got. Now I am convinced what Justice Prakash said and Justice what my judges of the Madras High Court, Justice Sundresh and Ramasubramanian said, absolutely true. The law is crazy. I have illustration after illustration where law has been unable to go and is in search of truth and find it out. No matter that we know what is the truth, proof has defied truth, and proof has succeeded to the extent that falsehood has prevailed. Why it is so? That is because just as Justice P. N. Prakash has written in his introduction, that was a real eye-opener. Coming from a presiding judge who is a puny judge, saying that we have a cultural mendacity in our blood. That was too hot a subject for me to read, but he gave a wonderful quote there. P. N. Ramasamy quote. He did not say it himself. We seem to have a culture of mendacity. For that also he associated with our native Indians were not basically false, were uttering falsehood. They were truthful. Even before a goddess, they used to swear, and that was truth. That Chor Ramaswamy, a great journalist, used to say, law of evidence prevailed only when the native Indians were there. Ever since Stephen and the Britishers came, we have lost the art of sticking to truth. That's what Chor Ramaswamy said. See, that is where we have gone. Now, law and truth to merge. I think perjury should be taken hold of as a serious offense that is being committed by witnesses. We have the instances of members of parliament in Britain. You take the great Jeffrey Archer, who wrote, he was punished for perjury for 5 years. And when I watch live television on the American television, the courts going on, perjury is a huge offense. They don't let out people. They even compromise on a plea bargaining, even for murder or dacoity, for manslaughter or lesser offenses, but never for perjury. We should get back. That should get back. In that context, Justice P. N. Prakash attack Pandey judgment, which is now pending before this Supreme Court, was a great eye-opener. 165 Evidence Act was really gone into, exploited to the maximum. Justice J.R. Midha was one of those who really laid store by 165, even in the High Court, despite what had happened in the trial court. In Attack Pandey, 165 was a clear eye-opener, and also 65B, Evidence Act, on which we have focused our lot of attention. And just as Justice P. N. Prakash said, we have gone bold. We have made bold. I am a senior citizen. Sharad is only about 37 years old. I read somewhere that Justice Nariman became a senior advocate at all of 37 years. This man deserves to be made in the presence of all the judges who are listening. I am urging them to make him a senior advocate much ahead of most others. He deserves to be there. With these words, I commend the book to the audience to be bought and hand over the podium to my learned colleague, Mr. Sharad Chandran.
Truth, fact, and proof. A triad for a trial. Thank you, sir, for those reflections. It is my duty to call upon the co-editor and author, Mr. Sharad Chandran, whose labor of passion has left an indelible imprint on this work, to say a few words along with delivering the vote of thanks.
Respected Justice U. Lalit, Justice V. Ramasubramanian, Justice M. Sundresh, Judges of the Supreme Court of India, Justice P. N. Prakash, the other judges of the Madras High Court who have joined us virtually, members of the bar, ladies and gentlemen. When Mr. Vijayaraghavan rang me up one rainy afternoon in August and asked me whether I would like to join him in revising Ratanlal Dhirajlal on evidence, I was overcome with the irresistible impulse to say yes. And I often wonder whether there was something sentimental in that answer, since the first law book I had purchased when I was in law college in Pune was this Ratanlal Dhirajlal on evidence, edited by the former Chief Justice of India, Y.V. Chandrachud and Mr. V.R. Manohar. The task of revising a book of this stature is no doubt a great honor, but it also presents certain problems of its own as a revising editor. I have learned that the essence is not what you put in by way of updating the work, but to ensure that what you pull out does not unwittingly blur the principles and alter the structure of the commentary. We trust and hope that our editorial revisions and in some cases omissions will meet with your approval. We are also happy to say that despite a rich and varied spread of case law from the Supreme Court and the High Courts over the past 4 years, we have managed to keep the waistline of this grand old book from burgeoning any further. In an extracurricular speech, the late Lord Reid once said in the House of Lords, "We turn a blind eye to the old rule that an academic writer is not an authority until he is dead, because once he is dead, he can no longer change his mind." In a similar vein, it is heartening to note that the Supreme Court of India has also drawn upon a considerable body of academic work, for example, in its recent decision in Vikash Kumar. In fact, I find that the earlier decisions of this very book have been cited by the Supreme Court in Sharda versus State of Maharashtra, State versus Navjot Sindhu, which is the starting point of the 65B debate, and the Ram Janmabhoomi case very recently. We are therefore hopeful that this edition, like its predecessors, would be useful to the bench and the bar. Lord Kanwat, a former judge of the UK Supreme Court, has once remarked, "Perhaps we as judges should cut out the theorizing and concentrate on doing justice in real cases. Where doing justice requires us to develop and refine new and more specific principles, we should be willing to do so. Generally, we should look to the academics to do the theorizing and to put our efforts into a wider context. That way, we can decide cases and they can tell us what we really meant so that we can make it better next time." While taking this opportunity to dedicate this edition to the legal fraternity, we trust and hope that the bar and the bench may find something in it which is useful to them to sound better next time in court. We are deeply thankful to Justice U. Lalit for very kindly consenting to preside over this event and for delivering his presidential address despite his busy schedule. I am also very grateful to Justice Ramasubramanian for gracing an occasion and was typically erudite forward with interesting anecdotes where he refers to the story of Sundaramurthy Nayanar from Periya Puranam, reminding us that many of our evidentiary rules are not necessarily of Anglo-Saxon origin. I'm deeply thankful to Justice M.M. Sundresh, who has always had a kind ear and a kind word for the juniors. We hope that we will continue to have your support and encouragement, sir, in all our future endeavors. I profusely thank Justice Prakash, not only for his searching introduction, but for also guiding us and giving us perspectives on certain knotty areas of evidence law. We are very deeply grateful to him for the time that he has spent, despite his busy judicial work, in examining some of our critiques and offering us his valuable inputs. I also thank all the other judges of the Madras High Court who have logged in virtually, members of the bar, and to grace the occasion. I also thank Mr. Shankar Narayanan, the Additional Solicitor General of India, for kindly consenting to give the welcome address. The team at CTC and Mr. Ramchandran, together with Mr. Ram Mayappan, for organizing this event. Thanks are also due to Mr. Arjun Bhargava, Radhika Kohli, Ms. Soumya, and Ms. Kanika from LexisNexis, and to Bhargavi and Ranganayaki for their beautiful invocation. And to finally, the man for all seasons and my good friend, Mr. Amrit Bhargav, for comparing the event. Thank you very much.
Thank you.
Thank you, sir, for those concluding remarks, so typical of your scholarly style and deportment. It was a great evening to remember and cherish, made extra special with our honored guests, their lordships and other distinguished invitees. And we are sure that the book would find a great place in law libraries across the country and rekindle the flame of interest in legal minds. On that note, may I call upon Ms. Bhargavi Vijayaraghavan and Ms. Ranganayaki Vijayaraghavan to render the national anthem.
गणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Leave the meeting.